Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session in July 2023, I want to talk about the new Flexible Working Act. Now, I'm not going to be talking about all the good things that come from flexible working. There has recently been a sort of cross-government trade union, business bodies like the CBI, IOD, Chambers of Commerce, FSB, the Equality and Human Rights Commission. Everybody's got together and have put together some really fantastic materials around that. That if you go to workingfamilies.org.uk and look at employers happy to talk flexible working, you will find out a lot more about the positives of flexible working and the badge that you might use to encourage flexible working from candidates when you're advertising, for example. Today I want to focus on the changes in the legislation to the processes that you might be used to. So we have for a long time now had the ability, if you've got 26 weeks service, to ask for flexible working from your employer, and the employer has a bit of process to follow, and then they can say yay or nay using one of the 8 business reasons to say no if they are minded to say no. Contrary to quite a lot of coverage that I've seen recently, this act, which doesn't come in for a year, so these changes, you've got a year to make, changes to your policies and training and things, doesn't come into force until July 2024, and it does not change the ability for somebody to ask about flexible working to day one of their employment. They've still got to have 26 weeks service. The government has committed to bringing in secondary legislation which will do that. They just haven't done it yet. So we don't yet have a date for when that change will happen. So a lot of the fanfare, if you like, around about at the moment is slightly misleading. Currently, somebody making an application has to say how they envisage the change that they're wanting to make would impact on the employer, and how those challenges perhaps that might come with that could be overcome. That falls away. Somebody doesn't have to do that, but I am still going to be telling employees, if they ask me, that they should address those sorts of things, because only a well thought through request sometimes gains any traction, and it's still going to be a good idea to show that you've thought through all the pitfalls and have an answer for them. But technically, somebody doesn't have to do that anymore. At the moment, we're limited to how many requests somebody can make, so they can only do one a year. Going forward, they will be able to make more than one. They'll be able to make 2, but they can't make a request whilst the first process is running. So if we are in a process, maybe there's an appeal stage, and that is still to be dealt with, they couldn't make their second request at that point. They would have to wait for the entire process to finish before they could then make a second request. Obviously, that potentially means more requests for employers to deal with, so issues around resourcing, issues around training of managers to spot requests, and also to not sit on them, because now the timescale, in a year's time, the timescale will be shorter. So at the moment, we've got to deal start to finish with cases in a 3-month window. That's going to be shrunk down to 2 months. The 8 business reasons that I referred to earlier, still very much there. So changes, but not massive changes. There is a requirement to consult the employee going forward. In the past, it's always been good practice to meet, listen to the employee, let them make representations before making up your mind. Now you have to consult with the employee. But consultation, if you're familiar with redundancy exercises, it's about that listening exercise. It's about taking on board what somebody said. Doesn't mean you have to do what they have said. So from the perspective of the employee, I'm not sure that this is going to be hugely groundbreaking. However, alongside flexible working processes, we have got the discrimination legislation. So employers do have to think more broadly. Is there a potential risk here in terms of something like the duty to make reasonable adjustments for a disability and a health issue? Is there a wider picture here around indirect discrimination? So somebody may be asking to work from home for childcare arrangement reasons. Indirect sex discrimination could kick in there. So, employers have got to always take these things seriously and perhaps get some advice as well. If you have any questions, please don't hesitate to contact me. It's adenton@refreshinglawltd.co.uk. Thank you very much.